Michigan Real Estate Exam Prep. Question 1. During a buyer consultation in Marquette, a branch manager encounters a rule involving the handling terms for property management money. Which response follows Michigan law, while the file concerns a retail suite, a property condition statement, and a dual-minus representation concern? Option A. Leave them to an oral understanding. Option B is state them in the written property management employment contract. Option C. Place them in the deed only. Option D. Let each tenant choose after payment. The correct answer is option B. State them in the written property management employment contract. The management agreement must address safekeeping, disbursement, use, and account treatment. The transaction context changes the facts, but it does not change the underlying licensing duty. A deed or tenant preference does not establish the manager's financial duties. Question 2. A licensee is preparing for an offer review in Pontiac. Which statement correctly addresses records requested by an authorized department representative during normal business hours, while the file concerns a manufactured home site, a property management ledger, and a protected class inquiry? Option A. Provide only advertising photographs. Option B. Require a court judgment in every case. Option C. Destroy the records immediately. Option D. Allow inspection of reasonably necessary documents and records. The correct answer is option D. Allow inspection of reasonably necessary documents and records. The department may examine business records reasonably connected to an investigation or regulatory review. A written office procedure should produce the same result in comparable transactions. The inspection authority is broader than a request for promotional materials alone. Question 3. Which Michigan requirement should control when a salesperson deals with a licensee selling property in which the licensee has an ownership interest during an open house, while the file concerns a 2-unit rental, a title commitment, and a disputed repair credit? Option A. Disclose the ownership interest and licensure in writing before an offer is signed. Option B. Tell only the lender orally. Option C. Disclose only after closing. Option D. Conceal the interest if the price is fair. The correct answer is option A. Disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. In the described setting, the brokerage should document the step and apply it before moving forward. Fair pricing does not excuse non-disclosure. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a brokerage audit, the brokerage discusses the purpose of a seller property condition disclosure. Which conclusion is most accurate? While the file concerns a historic residence, a seller net sheet, and an electronic signature. Option A. Replace the buyer's inspection. Option B. Provide the buyer with required information about known property conditions. Option C. Transfer title to the buyer. Option D. Guarantee the property will never need repairs. The correct answer is option B. Provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. The document neither substitutes for due diligence nor conveys ownership. Question 5. A compliance question in Grand Rapids concerns a known material defect that affects a purchaser's decision. Which action or statement is appropriate, while the file concerns a student rental, a property condition statement, and a referral arrangement? Option A. Hide it until after possession. Option B. Remove it from every transaction file. Option C. Communicate the material information as required rather than conceal it. Option D. Describe it as confidential pricing data. The correct answer is option C. Communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. For exam purposes, focus on the regulated relationship rather than an informal business custom. Deleting the fact from a file does not remove the underlying duty. Question 6. How should a Michigan buyer representative handle a situation involving a seller disclosure form compared with a professional inspection, while the file concerns a vacant commercial parcel, a property management ledger, and a team social media post? Option A. The form makes all contingencies void. Option B. The disclosure does not replace an independent inspection. Option C. The form guarantees structural soundness. Option D. The form is an appraisal. The correct answer is option B. The disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. The transaction context changes the facts, but it does not change the underlying licensing duty. Appraisal and contingency rights serve different purposes. Question 7. Which choice best applies the state rule concerning refusing housing minus related service because of a protected characteristic to a property management meeting, while the file concerns an industrial site, a title commitment, and a record inspection request? Option A. A lawful appraisal adjustment. Option B. Permitted client screening. Option C. A required agency disclosure. Option D. Unlawful discrimination. The correct answer is option D. Unlawful discrimination. Housing opportunities must not be restricted on a prohibited discriminatory basis. A written office procedure should produce the same result in comparable transactions. Agency paperwork or valuation methods do not justify unequal treatment. Question 8. A file from Muskegon raises an issue about directing buyers toward or away from neighborhoods based on protected characteristics. Which answer identifies the governing requirement, while the file concerns a new construction home, a seller net sheet, and a branch minus office distance issue? Option A. Steering and discriminatory practice. Option B. A lawful zoning variance. Option C. A neutral market analysis. Option D. A title search. The correct answer is option A. Steering and discriminatory practice. Neighborhood recommendations cannot be based on the protected composition of residents. In the described setting, the brokerage should document the step and apply it before moving forward. Title and zoning work do not authorize discriminatory channeling. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a transaction minus file review, which rule should the new applicant apply to advertising that indicates a preference or limitation based on a protected status, while the file concerns a mixed minus use building, a property condition statement, and a financing contingency? Option A. Permitted puffery. Option B. Discriminatory advertising. Option C. A lawful deed restriction. Option D. A required broker identifier. The correct answer is option B. Discriminatory advertising. Marketing language may not signal that protected people are unwelcome or preferred. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Broker identification and ordinary promotional opinion are separate issues. Question 10. A Michigan exam candidate reviews a scenario involving reasonable accommodation for a person with a disability. Which option reflects the current licensing framework, while the file concerns a cooperative unit, a property management ledger, and an unrepresented consumer? Option A. Treat the request as a commission dispute. Option B. Consider a necessary change to rules or practices unless an applicable defense exists. Option C. Require the person to waive civil rights. Option D. Reject every request automatically. The correct answer is option B. Consider a necessary change to rules or practices unless an applicable defense exists. Disability protections may require flexibility in policies so a person can use and enjoy housing. For exam purposes, focus on the regulated relationship rather than an informal business custom. A brokerage minus fee issue does not resolve an accommodation request. Question 11. The broker's policy manual addresses fraud, deceit, or dishonesty in licensed practice. Which provision should it contain, while the file concerns a farm parcel, a title commitment, and a confidential price limit? Option A. Grounds for occupational discipline. Option B. A protected marketing strategy. Option C. A required form of negotiation. Option D. An automatic contract amendment. The correct answer is option A. Grounds for occupational discipline. Dishonest conduct undermines the competence and trust expected of a licensee. The transaction context changes the facts, but it does not change the underlying licensing duty. Negotiation does not authorize intentional deception. Question 12. A regulator asks about gross negligence or demonstrated incompetence during a brokerage review. Which response demonstrates compliance, while the file concerns a lakefront cottage, a seller net sheet, and a change of employing broker? Option A. A substitute for continuing education. Option B. Conduct that can support disciplinary penalties. Option C. A protected advertising style. Option D. An exemption from supervision. The correct answer is option B. Conduct that can support disciplinary penalties. Serious carelessness and inability to perform regulated work can trigger professional sanctions. A written office procedure should produce the same result in comparable transactions. Education and advertising rules do not convert incompetence into lawful practice. Question 13. Which statement would be safest for a salesperson to follow when false advertising by a licensee becomes relevant, while the file concerns a townhouse, a property condition statement, and an owner-licensee conflict? Option A. A disciplinary violation. Option B. A method of deed delivery. Option C. A title-insurance requirement. Option D. A permitted team slogan in every case. The correct answer is option A. A disciplinary violation. Real estate marketing must be truthful and comply with brokerage-identification rules. In the described setting, the brokerage should document the step and apply it before moving forward. Deed and title procedures are unrelated to advertising honesty. Question 14. A dispute arises during a seller consultation over helping another person perform regulated brokerage work without a license. Which principle resolves the issue, while the file concerns a urban infill property, a property management ledger, and an expired license issue? Option A. A required referral method. Option B. A zoning enforcement function. Option C. Aiding unlicensed practice. Option D. Lawful delegation to any friend. The correct answer is option C. Aiding unlicensed practice. A licensee may not enable an unlicensed person to perform activities reserved for licensed practitioners. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Calling the activity a referral does not change its substance. Question 15. In Saginaw, an employing broker must decide how to proceed with practicing while a license is suspended, revoked, or lapsed. Which decision is consistent with Michigan requirements, while the file concerns a subdivision lot, a title commitment, and a property-management payment? Option A. Only advertising is prohibited. Option B. The license remains active for pending deals. Option C. The employer may privately reactivate it. Option D. The person is treated as unlicensed. The correct answer is option D. The person is treated as unlicensed. Authority to practice depends on a current license in good standing. For exam purposes, focus on the regulated relationship rather than an informal business custom. Only the department can restore lawful status through the applicable process. Question 16. Which exam answer accurately classifies the rule involving failure to comply with a final board or department order, while the file concerns a rural acreage, a seller net sheet, and a delayed possession term? Option A. A separate basis for discipline. Option B. A fair-housing exemption. Option C. An automatic license renewal. Option D. A private contract defense. The correct answer is option A. A separate basis for discipline. Final regulatory orders are enforceable obligations of the licensee. The transaction context changes the facts, but it does not change the underlying licensing duty. Private transaction terms cannot override the order. Question 17. A new policy is being drafted for keeping a client's confidential negotiating information private. Which language belongs in the policy, while the file concerns a single-family residence, a property condition statement, and a cooperating brokerage? Option A. A reason to hide known hazards. Option B. An optional courtesy after closing. Option C. A fiduciary responsibility subject to legal disclosure exceptions. Option D. A duty owed only to competitors. The correct answer is option C. A fiduciary responsibility subject to legal disclosure exceptions. Agency loyalty includes protecting confidential information obtained through representation. A written office procedure should produce the same result in comparable transactions. It cannot be used to conceal material facts that must be communicated. Question 18. During team training, the supervising broker tests knowledge of presenting offers and material transaction information promptly. Which answer should the team select, while the file concerns a small apartment building, a property management ledger, and a rejected counteroffer? Option A. Part of competent and loyal client service. Option B. Optional when commission is small. Option C. A task reserved for the assessor. Option D. A prohibited communication. The correct answer is option A. Part of competent and loyal client service. Clients need timely information to make informed decisions about offers and risks. In the described setting, the brokerage should document the step and apply it before moving forward. The size of compensation does not reduce professional responsibility. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain an owner selling the owner's property in an occasional transaction. Which explanation reflects Michigan law, while the file concerns an office condominium, a title commitment, and an assumed business name? Option A. Every owner must obtain a salesperson license. Option B. Only a lender may sell the property. Option C. The owner becomes a broker automatically. Option D. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. The correct answer is option D. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. Owners may generally handle their own property, but Michigan limits commercialized patterns of owner sales. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Ownership alone is not an unlimited exemption from broker licensing. Question 20. Which compliance step is required when the transaction facts involve an owner completing more than 5 property sales in 12 months without using a broker, while the file concerns a condominium unit, a seller net sheet, and a security minus deposit question? Option A. The transactions become tax minus free. Option B. The owner remains exempt without limit. Option C. Only a building permit is required. Option D. The activity is treated as a principal vocation requiring broker licensure. The correct answer is option D. The activity is treated as a principal vocation requiring broker licensure. Michigan uses transaction frequency as one indicator of professional real estate sales activity. For exam purposes, focus on the regulated relationship rather than an informal business custom. Tax and construction approvals do not replace occupational licensing. Question 21. A branch manager notices a potential problem involving an owner spending more than 15 hours per week over a 6-month period selling owned real estate. Which response should occur first? While the file concerns a retail suite, a property condition statement, and a dual-representation concern. Option A. The rule applies only to renters. Option B. The time is counted only after closing. Option C. The activity can be treated as a principal vocation. Option D. The owner is always exempt. The correct answer is option C. The activity can be treated as a principal vocation. Substantial weekly work devoted to owner sales can move the activity beyond casual disposition. The transaction context changes the facts, but it does not change the underlying licensing duty. Closing dates and tenant status do not control this test. Question 22. The state portion of the exam presents facts about the additional pre-licensure education associated with an individual broker applicant. Which result is supported, while the file concerns a manufactured home site, a property management ledger, and a protected minus class inquiry? Option A. 10 hours of advertising only. Option B. No additional education. Option C. 90 hours beyond salesperson education. Option D. 40 hours total including salesperson education. The correct answer is option C. 90 hours beyond salesperson education. Broker minus level preparation requires substantial coursework beyond the salesperson foundation. A written office procedure should produce the same result in comparable transactions. The additional requirement is not satisfied by repeating only the initial salesperson total. Question 23. Which brokerage practice properly addresses a salesperson license application under the statutory employer structure in the Muskegon transaction, while the file concerns a 2-unit rental, a title commitment, and a disputed repair credit? Option A. The employing broker signs or approves the affiliation required for issuance. Option B. The county clerk becomes the employer. Option C. The applicant self-employs immediately. Option D. A home inspector signs as sponsor. The correct answer is option A. The employing broker signs or approves the affiliation required for issuance. The salesperson credential is issued within an employing-broker relationship. In the described setting, the brokerage should document the step and apply it before moving forward. Independent practice is not created merely by passing the examination. Question 24. A licensee is comparing 4 procedures related to a salesperson license as to legal form. Which procedure is lawful, while the file concerns a historic residence, a seller net sheet, and an electronic signature? Option A. It is issued to a branch office. Option B. It may be issued to any corporation. Option C. It is issued only to an individual. Option D. It belongs to the property being sold. The correct answer is option C. It is issued only to an individual. Michigan treats the salesperson credential as an individual occupational license. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A location or parcel cannot hold a salesperson credential. Question 25. At the end of a closing preparation, the parties question an associate broker's status. Which statement provides the best guidance, while the file concerns a student rental, a property condition statement, and a referral arrangement? Option A. A county recording officer. Option B. An unlicensed assistant. Option C. A salesperson with no broker qualifications. Option D. A broker minus qualified individual working for another real estate broker. The correct answer is option D. A broker minus qualified individual working for another real estate broker. An associate broker has met broker licensing standards but practices through an employing broker. For exam purposes, focus on the regulated relationship rather than an informal business custom. It is distinct from clerical assistance and ordinary salesperson status.